Alright, so quick housekeeping matter before the episode begins. So, as you may know, in the episodes up till now, I've been going through the 2024 term opinions, and we are now moving on to the first 2025 term opinions. I do still intend to read all of the Supreme Court's 2024 term opinions. We're just moving on to the first 2025 term opinions because a few of them have been released, and I don't want to get too far behind on the 2025 term, because once we start getting some of the more important or influential cases decided, I want to be able to get episodes on those decisions out relatively soon after they're released. But again, am still going to be reading all of the 2024 term opinions, and some of them probably will be interspersed throughout the 2025 term, the rest of the 2025 term, as gaps between new opinions being released arise. So the episodes will not be in the chronological order that the opinions in them were released. So if there are any people like me that would like to listen to opinions in chronological order according to what term that they were released in and when they were released, I will try to make playlists or collections or whatever on as many of the different hosting platforms as I can to accommodate that. That's already done on YouTube because it's pretty straightforward and easy to do on YouTube. So there are already playlists made corresponding to specific terms. But on hosting platforms where that isn't possible, unfortunately, you won't be able to read them or listen to them rather in chronological order. So with that, we'll get on to the episode. In episode 10 of the Supreme Court Opinions Read podcast, I'll be reading the Supreme Court's opinion in Pitts versus Mississippi. The case was decided November 24th, 2025. And in this case, there is no syllabus, so we will move right on to the opinion, which was written per curiam. Ordinarily, the Sixth Amendment's Confrontation Clause guarantees the defendant a face-to-face meeting with the witnesses appearing before the trier of fact. In child abuse cases, however, that rule sometimes gives way. Consistent with the Sixth Amendment, a court may screen a child witness from the defendant when necessary to protect the child from trauma that would be caused by testifying in the physical presence of the defendant, at least where such trauma would impair the child's ability to communicate. Still, before invoking this procedure, a court must proceed with care. It must hear evidence and make a case-specific finding of the requisite necessity. Simply pointing to a state statute that authorizes screening, even one premised on generalized findings of necessity, will not suffice. Because the Mississippi Supreme Court departed from these principles, we reverse. Part 1. In May 2020, AGC spent a weekend visiting her father, Jeffrey Pitts. After returning home, AGC told her mother that she had been sexually abused. Eventually, that report led to criminal charges against Pitts. At trial, the state moved for permission to place a screen between AGC and Pitts when she took the witness stand. In support of its motion, the state pointed to a Mississippi statute providing that child witnesses shall have the right to a properly constructed screen that would permit the judge and jury in the courtroom to see the child, but would obscure the child's view of the defendant. Pitts objected. He did not question the statute's mandatory terms, but he said those terms had to give way to the Sixth Amendment's demands. And he submitted the state had not attempted to meet and could not meet its Sixth Amendment burden of showing that screening was necessary in the particular circumstances of his case. The trial judge granted the state's motion. In doing so, the judge reasoned that the statute appears to be mandatory and expressed concerns about his ability to declare the statute unconstitutional and fail to follow it. After a jury convicted him, Pitts appealed. Invoking Coy and Craig, he argued that the trial court had failed to make the case-specific finding of necessity the Sixth Amendment requires, and as remedy sought a new trial. Ultimately, a divided Mississippi Supreme Court rejected Pitts' arguments. The court did not dispute that the trial court failed to make a case-specific finding of necessity. Instead, the court sought to distinguish Coy and Craig on various grounds. With those distinctions in hand, the court then proceeded to hold that Mississippi's mandatory statute provided sufficient authority for the screening in this case. Unpersuaded, a dissent argued that Coy and Craig controlled this case and that the trial court failed to comply with their terms. After the Mississippi Supreme Court ruled, Pitts sought certiorari. Part 2. Under Coy and Craig, a trial court may not deny a defendant his Sixth Amendment right to meet his accusers face-to-face simply because a statute permits screening. Nor may a court authorize screening based on generalized findings of necessity underlying such a statute. Instead, the Sixth Amendment tolerates screening in child abuse cases only if a court hears evidence and issues a case-specific finding of the requisite necessity. The Mississippi Supreme Court attempted to avoid these constraints by distinguishing Coy and Craig in various ways, but none of the court's distinctions persuades. Consider the most salient theories it pressed. First, the court pointed to a victim's rights provision in Mississippi's state constitution. That provision affords the state legislature the power to enact laws to protect the rights guaranteed to victims. And the court observed the state legislature exercised this power when it adopted the mandatory screening law the trial court applied in this case. But, true as all that may be, it is also irrelevant. When state law conflicts with the federal constitution, the latter controls. And under the Sixth Amendment, neither state screening statutes nor the generalized findings on which they are premised are enough to overcome a defendant's right to face-to-face confrontation. Second, the court stressed that Mississippi's statute mandates screening in child abuse cases, while the Iowa statute in Coy only afforded trial courts discretion to screen. But if anything, the fact that Mississippi's statute is mandatory and thus never requires a case-specific finding of necessity renders it more constitutionally problematic than the statute at issue in Coy, not less so. Third, the court emphasized that AGC was 4 years old at the time of trial, but Craig involved a 6-year-old witness. And though a witness's age is a relevant consideration, Craig made plain that a court must hear evidence and make a case-specific finding of necessity before denying a defendant the right to face-to-face confrontation in a child abuse case. Fourth, the court observed that in Coy, the government and the defendant disputed who committed the alleged assault, while in this case the identity of the alleged perpetrator was not in question. But the Sixth Amendment right to confront one's accusers face-to-face does not only apply in cases where identity is at issue, nor does Craig's exception for child abuse cases automatically apply just because identity happens to be uncontested. Finally, the court noted that the child witness and lawyers in Craig were placed in a different room from the defendant, with cross-examination conducted over closed-circuit television. In this case, by contrast, everyone remained in the courtroom, the witness and defendant separated only by a screen. But both approaches deviate from the Sixth Amendment's usual rule that a defendant is entitled to meet his accusers face-to-face, and both thus require a case-specific finding of necessity. Before this court, the state does not so much defend the Mississippi Supreme Court's various efforts to distinguish Coy and Craig as press a different argument still. As the state sees it, the trial court did hear evidence and make a case-specific finding of necessity. We disagree. At trial, to be sure, the prosecution represented that AGC's guardian believed it would be difficult for her to testify face-to-face with her father. But the prosecution expressly rejected the notion that it had to put on any proof, choosing to rely instead on Mississippi's mandatory right to screening. And the trial judge proceeded to rule that the statute appears to be mandatory and expressed concerns about failing to follow it. Those arguments and conclusions fall well short of the procedures and findings Coy and Craig require. Part 3. Having resolved that much, we pause to underscore what we leave unresolved. Just because a constitutional error took place at trial does not necessarily mean a new one must be held. Even constitutional errors are sometimes subject to a harmless error rule, and do not require a new trial if the prosecution can show beyond a reasonable doubt that the error complained of did not contribute to the verdict obtained. This court has held that the denial of the right to face-to-face confrontation is among those errors subject to that harmless error analysis. Accordingly, on remand, the state remains free to argue and the Mississippi Supreme Court remains free to consider whether the error in this case warrants a new trial under the harmless error standard. The petition for certiorari is granted, the judgment of the Mississippi Supreme Court is reversed, and the case is remanded for further proceedings not inconsistent with this opinion. It is so ordered. And that is it for the opinion in this case. Very short one, very quick one, a mere few pages, which is probably why it was released as soon in the term as it was. Spoiler, the next couple opinions are going to be of the same sort. But yeah, it seems pretty straightforwardly correct to me. If you're going to, if you're going to, have any situation where, you can overcome a defendant's Sixth Amendment right to physically face, face to face his accuser, come face to face with witnesses against him, you've got to, at the very least, make some sort of case specific, factual determination that this is actually necessary. And in this instance, the Supreme Court's precedents apparently say this very clearly that, in child abuse cases, you need to make a factual case specific determination that coming face to face with their abuser would impede the child's ability to testify. And the court didn't make those determinations here, and so it seems pretty straightforward. Yeah, you remand to say, hey, do it again. I know the state, I assume, wasn't asking the court to overturn those precedents, but just to comment on them quickly, I think they're probably fine. It seems fine to me to say, yes, generally a defendant has a Sixth Amendment right to physically face his accusers in the courtroom, but when his accusers are children who can't testify because they've been traumatized by the defendant's abuse, by the defendant's alleged abuse, and facing the defendant would impede their ability to testify, then yes, it's okay to do something as minor as, put a barrier between them, especially because you're still enabling the jury to see the witness, and that's, really an important part, is that the jury needs to be able to see the witness, because the jury needs to be able to determine the witness's credibility. And, well, if they can't see them, that takes, part of the set of information they can use to determine a witness's credibility off the table. That said, it's also worth noting the Sixth Amendment doesn't specifically say a defendant has a right to come physically face to face with witnesses against them. It says they have a right to be confronted with witnesses against them. And so one could argue that doesn't necessarily mean literally physically face to face. It could mean, hey, they have a right to cross-examine witnesses. They have a right to be in the courtroom with their witnesses, so that they can actually hear what their witnesses or what witnesses against them are, testifying to, etc. But yeah, this case seems pretty straightforward and fine to me. And apparently all 9 justices on the Supreme Court, unsurprisingly. So I guess one last thing to comment on is like whether, the court leaves this unresolved, like whether the defendant should get a new trial. And honestly, I kind of think like when it's a constitutional error, saying like, oh, well, that could be a harmless error, I don't know that I'm a huge fan of that. If the state is making constitutional errors in a criminal trial, saying, oh, well, that was probably harmless, I don't think, even proof beyond a reasonable doubt that it wouldn't have changed the verdict, I don't think is enough. I think a person has a right, constitutional rights to, a fair trial consistent with all of the provisions in the Bill of Rights. And if they're being deprived of that, even harmlessly, they are being deprived of their rights under the Constitution. Like, that's a problem. Um, now I think if the state can show, well, like maybe if the state can show the Mississippi Supreme Court, like, okay, well, if we had done the factual analysis, like, here's how that would have come out. And it would have come out in our favor anyway. We could have put a screen between the child and the defendant anyway. Then maybe you can say, well, it was harmless because the defendant wasn't actually deprived of their Sixth Amendment right, because even doing the factual, analysis that they were supposed to have done, uh, the state would have overcome, this Sixth Amendment right to physically face uh, the child witness. Maybe then I could see a harmless error argument, but if he was actually deprived of a Sixth Amendment right, I don't care if it, personally, I don't care if it wouldn't have changed the outcome of the trial. He has a right to a trial in accordance with the strictures of the Bill of Rights and nothing less. So you can't convict him on anything less. That's my thoughts on it. But yeah. That's I think just about all I have to say about this one. Again, very short one. The next two, spoiler, are going to be very short ones as well. So yeah, with that, if I may ask you, my friends on the other side of the screen, please like, share, comment, do all that stuff. Follow the podcast wherever you happen to follow podcasts. And if you would like to support the podcast, you can do that on Patreon. The main content of the show will always remain free, but Patreon members have access to episodes early and any bonus or exclusive content, and they can request specific content, including other than reading Supreme Court opinions. With that, tune in for the next episode where we will continue on through the first opinions in the 2025 term. Till then.